be seated.
Mr. Tipton?
The defense has no witnesses, and so we rest.
Okay. All right, so you renewed your required finding motion, and the same ruling on that, and I'll hear you on closing argument.
We're asking you, the court, to find Ms. McGee not guilty. The quality and reliability and the credibility of the Commonwealth's case rests on two witnesses, Dr. Dietrich and Susie Savage. I'll deal with Ms. Savage in a second, but first I will briefly talk about Dr. Dietrich. Dr. Dietrich's testimony includes an absurd and unlikely proposition that if someone is attacked in a room and the attacker dies as a result of his own conduct and anger, or whatever the emotion is, caused a rush of hormones that resulted in a cardiac event, that nonetheless the presence of the second person, the victim, would result in a finding, a medical examiner's finding of manner of death as homicide. It's an absurd and illogical conclusion that I think should surprise everyone. It's one that puts in jeopardy our own common sense notions of what is right and what is wrong. The government's evidence started with the testimony of John Savitz. They introduced a number of exhibits that were emails and texts. Emails and texts that really tell the court nothing when it comes to what this case is all about. And what is this case all about? It really boils down to two things. What constitutes the precipitating event that led to the cardiac event? And second, the presence of self-defense. Those exhibits were not introduced for any basis of bad act evidence. That was the agreement of the parties. They were introduced to try to show, at least was represented, the knowledge on behalf of Ms. McGee as to the medical conditions at issue that are raised under the definition and the instruction of involuntary manslaughter, whether it's based on a theory of non-felonious battery or if it's based on a theory of wanton or reckless conduct. And that standard is what Ms. McGee knew or what she should have known. Now, regardless of the fact that those exhibits contain some statements that may be construed as Ms. McGee's upsetness or anger with the brother-in-laws for not being as helpful as she liked or wanted, it says nothing about the proof and lack thereof of proof in this case. She went to 40 Meadowbrook Road the night this all happened because she was living there temporarily. We are talking in this case based on the evidence of a relationship between two people who have known each other for 15 years, were married for 15 years, and then divorced. And when this tragedy happened, they had been divorced for 6 years. During that time, though, even after the divorce, they stayed in close proximity, 79 Randolph and 40 Meadowbrook. They had 3 children. The 3 children lived with him. The reason I say that is because I believe that the court should consider the evidence of the relationship and the fact that at times there were, in fact, arguments. And then that goes to this whole issue of verbal altercation and vigorous verbal altercation that I'll just briefly touch on in a moment. She was evicted by the trust that was controlled by one or more of the brother-in-laws. It was upsetting. There may have been some anger, but the final eviction occurred on January 3rd of 2020, over 2 weeks before this incident. But the eviction had been ongoing. And so when the Commonwealth tries to argue that anger was the driving force when Miss McGee entered the home at 40 Meadowbrook, I'd ask the court to carefully consider all of the facts. And that's why I raised the issue of a long-standing relationship that continued even after divorce to share the responsibilities of raising 3 children and getting the older ones into college and caring for the younger one. Pointing out some suggestion that the trust in evicting Miss McGee was a terrible event or a terrible choice, or showed some evidence that the trust did not care for Miss McGee, that's not relevant to this. What is relevant is what that evidence speaks to the bias of John Savitz, the witness, and the way that he characterized some of the testimony. But he's not a major witness in this case. And this case isn't about judging Mr. Savitz and his feelings toward Miss McGee, or his pain and suffering from the death of his brother. His bias, the question is, does his bias infect also the bias of Susie Savitz? And that is what is critical in this case. That Susie Savitz's recitation of what she thinks happened began to have differing versions from the very night it happened. She told the police at the scene a story. 3 hours later, when asked on cross-examination, she admitted that some of the things she told the police at Barrison's house seemed to be different. She might not have admitted it different, but she acknowledged that she said some of those statements. Some of the statements she could not remember. As recently as August of 2024, she made different statements. As recent as January 22nd of this year, she made different statements. The state of the evidence is that she made different statements on the very day that she testified in this court. The fact of that is not to characterize a young woman as a liar or a bad person or anything of the sort. It is simply to set forth what the evidence shows, and it's the inconsistencies that give rise to the credibility and reliability of her recitation of facts. There is no blame to be laid at the feet of Susie Savitz for this tragedy. There's no blame to be laid at her feet for anything. She recited what she thinks she saw. But it changed over time. It changed right up to the moment of trial. And what we do know is that Susie Savitz never saw what actually happened at the beginning. She was upstairs. What she saw was a piece of something that in the middle of what can only be described as chaos, upsetting, and a visual of her mother and father struggling. That's what she saw. And whether she's biased to the point where she would like to make her father the victim, maybe that's what she'll believe for the rest of her life. But that's not what is at issue here. It's to take into consideration her changing narrative and the fact that the Commonwealth chose to rely on that changing narrative and put her on the stand to testify. In the face of these known inconsistencies and then evolving inconsistencies right up to the day, the Commonwealth continued to choose to put on this young woman in the stand. And, this is not to indict the Commonwealth either. And make no mistake, Anything I say in this closing argument on behalf of Ms. McGee is not to suggest that the prosecution in this case did anything corrupt or untoward or anything of the sort. As I criticize the proof, I'm criticizing the proof itself as it applies to the standard that I know this court will apply, and that is proof beyond a reasonable doubt and to a moral certainty. While I will say, honestly, on behalf of Ms. McGee, that I do not believe the prosecutors in this case were corrupt or misleading, what I do think is that they were misinformed and they were misled. By who? They were misled by Dr. Diedrich. Had there been an honest conversation, a fact-based conversation, where what came out in this trial was that the anger, the conduct, the emotional response to his own physiological reaction in the argument with Ms. McGee could have produced what we've referred to as the precipitating event that led to the cardiac event. Nowhere in the documents produced, nowhere in the direct examination or the redirect examination did Dr. Diedrich admit that. That came out on cross-examination. And why is that so very important? Because it raises not just a reasonable doubt, but one of the most significant reasonable doubt issues in this case, if not the most. We heard repetitious testimony about the use of the term homicide in the context of manner of death. And for reasons that confound me, the repeated answer, the repetition was that homicide does not mean anything more than at the hand of another. But what is this case about in this so-called homicide by heart attack case? It means that the conduct leading to the cardiac event is what at issue. Who is responsible for that conduct? And the indictment, the way it reads, the way the Commonwealth presented their evidence, was that it is Miss McGee's fault for the precipitating event. It was her conduct that caused the rush of hormones, as was testified to on direct by Dr. Diedrich. But now we know. That is not proof beyond a reasonable doubt, because in this courtroom, as in any courtroom, when you have two opposing but equally inconsistent theories, neither one could be proven beyond a reasonable doubt. And that is based on bedrock case law, and that is what the evidence is. I could go over many statements that Dr. Diedrich said that are in evidence, but I can reduce it to one set of cross-examination, questions and answers. You would agree, Dr. Diedrich, that Mr. Savitz's own anger could have been the cause of the precipitating event. Yes. You would agree, Dr. Diedrich, that it is impossible to determine whether it was his own conduct or the purported conduct of Miss McGee that was the precipitating event. Yes. It's impossible to say. If the Commonwealth tries to argue today that there is some contributory theory, they did not elicit anything of the sort from Dr. Diedrich. And in fact, Dr. Diedrich would have answered that. It's impossible to say. So that raises a significant reasonable doubt about whether any conduct of Miss McGee on the night of January 28th of 2020 was responsible for the precipitating event. What of the injuries? They are not relevant. What we learned on direct examination, that required then no extensive cross-examination, thankfully, was that the blunt trauma injuries did not cause the death. And there was a question then, and I hope the government doesn't try to argue it, but the question is, Dr. Diedrich made it clear, I don't even know when they happened. And I don't know how they happened. If those injuries could have happened some other time, in some other setting, for some other reason, they have no relevance whatsoever to anything in this case. Dr. Diedrich admitted that these are controversial cases and they're complex cases. She agreed with me when I pointed out all of the literature that she herself testified to on cross-examination, that she relied upon, that she referred to in reaching a manner of death in a case like this. And what does that literature, some of which was admitted into evidence, but the statements of Dr. Diedrich say? It says that they are complex, they are controversial, that manner of death opinions in these cases require careful and meticulous investigation on the part of the medical examiner. Dr. Diedrich seemed to have a flawed interpretation of the exhibit of Dr. Turner's Homicide Revisited, where his first factor doesn't include the term criminal conduct of the perpetrator and aggressor, whereas Dr. Davis's article, dated 1978, clearly says that. And I think the testimony is that Dr. Diedrich seemed to believe that Dr. Turner wasn't talking about criminal activity. But in fact, when confronted on cross-examination with Dr. Turner's own words contained in that exhibit, she finally admitted on the second day of her testimony that in fact he was talking about criminal conduct. So what is the criminal conduct here? That's for the Commonwealth to argue based on what they believe the facts show. But what we know at best is a conflicting description of either a few slaps, one slap, some pushing, one push. That is the state of the evidence. And even if you assume those facts to be true, it does nothing whatsoever to extinguish the reasonable doubt that is clearly established by Dr. Diedrich's admission for the first time during this trial that anger, that emotion generated by Mr. Savitz himself could have been the precipitating event that led to the cardiac event. Dr. Diedrich's approach to this case was, in essence, to ignore the importance of the self-defense statement that Ms. McGee made to the police at the scene. In Dr. Diedrich's view, in what I can only describe as an uninformed and distorted view, self-defense means nothing in the context of manner of death and homicide because of that repetitious pounding that homicide is a neutral term. But it's not a neutral term in this case. It implies, and in fact, Dr. Diedrich admitted, that it implies that it is Ms. McGee who's responsible for the precipitating event that led to the death. And now we know there is no proof of that beyond a reasonable doubt, if there's any proof at all. Imagine the slippery slope we would engage in this society, but particularly in this case, if we allowed a medical examiner to ignore self-defense in reaching their opinion as to manner of death. And this is the same medical examiner who made findings of causation and manner of death without being fully informed, and then when provided with the proper information that existed before she made that particular causation finding and that particular manner of death finding, in the eventual death of a state trooper. When she was provided that information, she admitted on the stand that she changed her causation, and her manner of death was changed to undetermined. And what is telling about that, even though the cases are different, and I am the first to admit that, it talks about the methodology and the flawed methodology of Dr. Diedrich. And she seemed to say on cross-examination that it was somebody else's fault. Those were not words, her words, those are mine. But she said, yes, that information was not provided to me before I made my finding of manner of death. Whose responsibility is it, if it's not the medical examiner's responsibility, fully aware of a disease that could end in death, and not inquire as to blood tests and inquire about the relevant literature that seemed to put in complete dispute her manner of death finding in that case, resulting in a nolle pros. And that goes to her methodology and the reliability and credibility of her opinion. The knowledge. What is the knowledge requirement in this case? It's this: Miss McGee knew or should have known that her conduct created a significant likelihood that substantial harm could come to Mr. Savitz. So what is the evidence of knowledge? She knew he had a stroke. She took care of him. She took care of him to the degree that she got him back on his feet, or at least helped him do so. And at the time of January 28th, he was working. We know that he was driving cars and operating motor vehicles because on or around January 20th, he got into yet a second motor vehicle accident, resulting in the totaling of his older son's car, Noah. What is the knowledge that we can impute to Miss McGee regarding the element in this case? That she thought that getting into a verbal argument would raise a substantial harm to Mr. Savitz? What she knew was, if you even impute what is contained in over 1,500 pages of medical records that Dr. Diedrich never bothered to look at, what you see is repeatedly references beginning in the early months of 2018 up until the end of 2019, leading to January of 2020, that his diabetes mellitus was not causing any substantial problem, but it was a significant medical condition. But there's nothing in those records, in all of the hundreds of pages of records, where any doctor who is examining and providing treatment to Mr. Savitz has told him, curb your physical activity, don't do this, don't do that, other than watch your diet. Maybe you should exercise more. The court asked for particular citations to those 1,500 pages of medical records, and we provided those, as did the Commonwealth provided their own. But I think what's important for purposes of the state of the evidence is that it's exhibit number 4, and it's the limited production of the Newton Wellesley Hospital affiliated with Mass General Brigham that were submitted. And I will just represent to the court that the voluminous second submission of Newton Wellesley records, exhibit number 63, they contain these very same documents, but since they're in a different format, it was kind of hard to find them and to set them forth. So I will say that everything I'm about to say is contained in both sets, but I will just read. And I'm now focusing on page 11 of exhibit 4, where there was a cardiological workup, and it was in relationship to the cerebral vascular workup that they were following Mr. Savitz on August 20th of 2019. And in the context of reviewing his physical condition Newton Wellesley conducted this cardiology examination of his heart, a detailed examination. And what are the result findings is found on page 11 and go into page 12? That his left ventricle wall thickness and cavity size appear grossly normal. His left ventricular systolic function is normal. His right ventricular size is normal. His right ventricular systolic function is normal. His left atrium is normal. His right atrium is normal. His mitral valve has no evidence of stenosis, as described, and we got the definition of stenosis from Dr. Dietrich. His tricuspid valve appears normal. His aortic valve, there's some thickening. There's no evidence of valvular aortic stenosis. There is no evidence of pericardial effusion, fluid around the heart, as the ER doctor testified to. That he saw no such evidence when he examined Mr. Savitz on January 29th of 2020. I could go through pages and pages of these 1,500 pages. And I submitted a list, and I understand, as the trier of fact, the court has had occasion to look at it. There is nothing in these records that show there was any concern by multiple doctors in different situations where they did routine as well as exacting and specific examinations of Mr. Savitz's heart and saw nothing truly abnormal, and that his heartbeat was normal. No evidence of heart murmur. The reason this is so important is because it goes directly to the level of knowledge and the quality of knowledge of Ms. McGee. It does nothing to put into dispute this reasonable doubt about what in fact caused precipitating event that led to the death. But since the government has a burden of proof of knowledge, we submitted and agreed to submit all of these medical records because they demonstrate, in essence, what I'll paraphrase Dr. Dietrich said on cross-examination. You could not tell whether Mr. Savitz had serious cardiac disease until you conducted your internal autopsy. I asked her, do you think you would agree? No layperson would know that he suffered from that. She ultimately agreed with me. She answered the same question when I talked about yesterday about his diabetes. She answered the same question to a lesser degree about the hypertension. What she didn't know was what the records show. And that's that the hypertension that Mr. Savitz was experiencing, otherwise known as high blood pressure, is framed throughout these records as essential hypertension, and at least Dr. Dietrich agreed with me that that tends to appear in 85% of the population. And Dr. Dietrich agreed with me that people with that type of hypertension and people with diabetes can function every day in a normal environment, notwithstanding those diagnoses. And that goes to the knowledge element required that the government demonstrate beyond a reasonable doubt, because it is an element. And I think I heard the government say in their required finding argument yesterday that the standard isn't what she knew, it's what an ordinary person should know. It's an alternative. It's a subjective and an objective standard. So, whether it is subjective or objective, the Commonwealth has failed to even prove that, beyond a reasonable doubt. And the case I cited in my required finding memo, but I will argue it here, or I'll just reference it again, that the description of the blows, even if the court credits that testimony, the description of the blows are blows, minor blows, open hand, whether they happen 5 or 6 times, whether they happen once, they are minor blows. And what does that case say? It basically says that that seems to be some evidence of knowledge, exculpatory evidence of knowledge. The other thing that is so critical here is that Dr. Dietrich, for reasons that confound me, but that's not relevant, but I hope that the court considers that Dr. Dietrich ignored the very cautionary warning contained in Exhibit 67, a 2018 piece of literature where her own association, National Association of Medical Examiners, warned that medical examiners should not attempt to perceive and use perception to determine whether someone experiences fright or is frightened, or to use perception to determine the intent of the perpetrator. I had to read it to her. I had to lay it out, but it's in the record. And at the end of listening to that paragraph, after she tried to say they were only talking about that scenario 4, I pointed out that they didn't qualify their statement at all. In fact, they referred to another scenario, scenario 8 also. What is the danger of that? It's because with very limited information, a medical examiner should never be using their own subjective analysis in the absence of firm foundational proof of the intent. And I'm talking about these cases. I don't care what Dr. Dietrich does in her other cases. I don't care what other medical examiners do in their other cases. I am talking about this case. I will touch briefly on the evidence that the government continued to submit, and I only touch upon it now because they raised it in the required findings, so I presume they're going to raise it here. The issue of alcohol. The issue of wine bottles in a car. My recollection is, Your Honor limited the introduction of the pictures of where the car was parked. And what is confusing to me is when I review the pictures of the exhibits that were submitted, and I might have them wrong, and I know it's the court's memory as well as the state of the evidence that stands, not mine. But the photographs I've seen of the car that were introduced are the car parked in the driveway. And in fact, when the question was posed to the trooper who took the pictures on direct examination, he seemed confused about the question. But that's neither here nor there. Because really what the government is trying to say was either the car, the way it was parked, or the content of the car goes to either anger or some argument about intoxication. And I suppose the government would think that there was some kind of proof that she was either under the influence, Miss McGee, and that then contributed to some kind of anger. Once again, even if it was true, it would have nothing to do. It would not affect one thing about what Dr. Dietrich admitted on cross-examination, and that it is equal, consistent, that it was Mr. Savitz's own conduct that led to the precipitating event. But I address it because I presume the government will. Let's talk briefly. Aside from Susie Savitz, no officer testified and no evidence came in that Miss McGee appeared angry that night. Nothing. Let's talk about intoxication. We're talking about a woman who has an argument with her ex-husband, and when he collapses, she administers CPR for approximately 5 minutes until first responders, and I think it was Brookline Police Officer Yanez, was the first to appear on the scene. And she is there administering for minutes. She then stands up when the first responders take over, and I believe the testimony was she stood nearby in that hallway where the tragedy occurred. And then she was told and instructed to move into the living room area only 10 or 12 feet away. And she did that. So she's following direction. And then she is approached by officers during this chaos and this yelling and this tragedy unfolding in the hallway. And she's asked questions and she gives answers. And my memory, and it's the court memory that controls, and it's the evidence that controls, is that Officer Yanez was asked on cross-examination, you don't include anything in your report about she appeared intoxicated. No, you had no reason to believe she was as you talked to her. No. And then we had the testimony of Officer Russell, and how did he describe Miss McGee? At the same period of time, he described her as first anxious and in shock. And he had no evidence to believe she was under the influence. And then she's taken ultimately to the Brookline Police Station, and we heard from Officer Richards, the booking officer, and what did he say? I go through these forms when I book her. Exhibit 60, 61, and 62. And one of the questions was, have you had any alcohol? And she forthrightly said, yes, about 7 or 8 p.m. It's in the evidence. And then he goes through a litany of questions. And one of them that he did not check, because as he told the court there was no evidence of it, is whether she was under the influence of alcohol. And then finally, when I showed him the Brookline Police Department policies relevant to where you have an intoxicated detainee, because she was detained, did you have to implement any of those procedures? No, because she was not. So when the government stands up, if it does, and hopefully they won't, and begins to argue this, I know the court will consider all of the evidence, and I know the court doesn't need to be reminded. Conjecture and surmise and guesswork cannot be used to reach a verdict. So what did happen? First, what happened was what Miss McGee told Officer Higgins, and it came into evidence without limitation. So it came in for its truth. And contrary to the distorted and illogical testimony of Dr. Diedrich on this singular issue, and as the instructions from the Supreme Judicial Court on the issue of self-defense as it applies to involuntary manslaughter, both on a theory of a non-felonious battery and on a theory of wanton or reckless conduct, where there is proper self-defense, the trier of fact must consider that, and where self-defense is exercised, of course, a defendant who exercised proper self-defense regardless of what happens to the attacker, death or otherwise. The defendant is not guilty. And I think that, I know the court will carefully consider the evidence. And what is the evidence? It begins with the testimony of Officer Yanez, and then it is supported by the exhibits, various exhibits of the home that were admitted, and the living room area, and the kitchen area, and the kitchen, and the hallway. And they're not sequential, so it's a little difficult, but the front door is Exhibit 14, and that's where she entered, where she was permitted to enter, where she had entered for quite a few days while she was allowed to stay there. Then you have Exhibit 21, which is the living room wall. And in that same photograph, but also in Exhibits 22, 23, 24, 25, is the living room, where the discussion began. And Exhibit 39 is the picture of the couches where they were seated initially. And then we go back to Exhibit 21, and as Miss McGee explained to the police, explain is the wrong word. Miss McGee was asked what happened, and she told the police as best she could what happened. And I asked the court to recall that during this recitation, as a response to the questions being asked, there was chaos going on about this distance, Judge, from where Miss McGee is seated here, as described by the officers, 12 to 15 feet, was where the chaos and the tragedy was, with yelling taking place as people struggled, EMTs, Brookline Police, to address the issue of Mr. Savitz. And so she enters the house. She wants to talk about a number of things, but the thing that she recalled, or the police recalled, she said, was she was there, as they described it, as an email about the eviction that had occurred about 3 weeks earlier. And I remind the court, probably don't have to, but I will. The government says she showed up angry and full of venom. Well, how come? Because the eviction had transpired 3 weeks earlier. She was upset, perhaps. Maybe she was. But that's not what she told the police. What she told the police was, I entered, we started discussing. The discussion escalated into a verbal argument. Mr. Savitz became belligerent. He told her to get out of the house. Mr. Savitz suddenly pushed her against the living room wall. He then continued to push her into the dining room. Dishes fell. That's what she told the police. She didn't say a bowl fell, or she just recalled something fell, dishes fell, and they broke on the hard tile floor. He pushed her into the refrigerator, is what she said. He grabbed her by the hair at that point. He began to push her down the hallway in an effort to get her out of the house. She's struggling. He's pushing her toward the front door. And now they're near the stairway. It's captured in the exhibits, captured in a number of exhibits. And he collapses. And what does she do? She administers CPR. And while this is going on, Susie Savitz has called 911. And so we have the benefit of listening to the tragedy, and I say benefit only because it is part of the evidence, and it was admitted into evidence. And what is telling about that 911? It is a terrible thing to have to listen to. But what is captured during the time leading up to Mr. Savitz collapsing is Susie Savitz telling her father, stop, 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 stop. Seconds later, Dad, stop, stop, stop. Seconds later, Dad, Dad. And then 1 second later, she screams because her father has collapsed. She's telling her father to stop. Whether the inference that flows from that is that she was telling her father to stop pulling mother's hair, stop pushing mother to the door, stop pushing, that's for the court to determine. But it's a fair inference. And what is present in that 911 is nothing directed at Miss McGee specifically. There is a statement, you guys stop, but nothing otherwise. It supports the inference that what Miss McGee told the police is entirely accurate and what happened. The government, on that issue, I just briefly talked about. When Miss Savitz was on the stand, they presented her with a photograph. And it was confusing at first. And it confused her, but it confused me. Do you see anything on the floor? And so we're looking at that photograph, and Miss Savitz rightly says, I don't know what you mean, or words to that effect. And then the Commonwealth put up another photograph and said, do you see anything on the floor? And that photograph included part of the refrigerator. The refrigerator that contained pages on the front of the refrigerator. And I don't know, but it seems to me what the government wants to argue, maybe they'll argue it today, maybe they won't, but are they suggesting that since the papers remained intact on the refrigerator, that Miss McGee's recitation of what happened when she told the police that Mr. Savitz pushed her in the refrigerator, that puts her statement in dispute? Well, then why didn't they put on any evidence of how those pages were attached to the refrigerator? Why didn't they put on any evidence of how easily or how difficult it would have been for those pages to fall had someone be pushed into that refrigerator? But if the government attempts to argue that argument, I only ask the court to consider this. Why is it that the government is asking that Miss McGee be held to some exacting and specific standard, especially given the fact that her statement was made where 15 feet away people are yelling and screaming, and she is in shock? Why do they require her to be in perfection? Why is it that the evidence shows in the photographs that right next to the refrigerator is another hard object, and that is the oven, one of those wall ovens? And so whether she was slammed into something hard and she thought it was a refrigerator or not means nothing. And why didn't the government then put on proof if they intend to argue that? And why do they hold Miss McGee to such an exacting standard when they do not require the same standard to be applied to their witness, Susie Savitz, or their expert, Dr. Diedrich? And as we go on, what we do know is then that Miss McGee is described as being in shock, and she doesn't leave. And what does she say in the middle of this tragedy as she is looking at her ex-husband? I have to go. I have to go with him to the hospital. Does that sound like the words of an angry person? Does that sound like somebody who doesn't care about her ex-husband? And she was told, no, you have to stay. That's the testimony of Officer Russell. You have to stay. And so she's eventually asked to go to the Brookline Police Station, and in an uncuffed manner, she enters the back seat. She is driven there. She's taken. She's eventually booked. And she's placed in a cell. And here we are. This court knows what proof beyond a reasonable doubt is. I'm not gonna pretend to even recite it, other than proof beyond a reasonable doubt to a moral certainty. And I know this quote will apply that very high standard to the facts of this case and ultimately reaching whatever verdict this court finds. And on behalf of Ms. McGee, I ask you to find it guilty.
Thank you very much. Ms. Mayor?
Look what you've done. Those were the words that Zuzi Savitz uttered to her mother, Penelope McGee, on the 911 call in the midst of her terror as her dad collapsed before her very eyes. Look what you've done. Those were the words that Zuzi Savitz uttered to her mother on the 911 call after she saw her mother shoving and slapping her father immediately before he collapsed. And it is this short time frame from when Zuzi witnessed her parents fighting to when her father, Andrew Savitz, ultimately collapsed and died that was so significant to Dr. Diedrich. I urge you, Your Honor, to recall what Dr. Diedrich told you. But for the altercation with Penelope McGee, Andrew Savitz would not have died that day. Now, the defendant, Penelope McGee, has been charged with involuntary manslaughter. And I will point out to you, Your Honor, that this is a charge that alleges an unintentional killing. There are two theories of involuntary manslaughter, the first being the unlawful killing unintentionally caused by wanton and reckless conduct, and the second being unlawful killing unintentionally caused by a battery that the defendant knew or should have known created a high degree of likelihood that substantial harm would result to another. I submit to Your Honor that the Commonwealth has presented evidence on all elements for both theories and has proven to this court both theories of involuntary manslaughter. But I would like to focus on the wanton and reckless theory right now. To find the defendant guilty of an unlawful killing unintentionally caused by wanton and reckless conduct, the Commonwealth must prove four things beyond a reasonable doubt: that the defendant caused the victim's death, that the defendant intended the conduct that caused the victim's death, that the conduct was wanton or reckless, and that the defendant did not act in proper self-defense. I submit to you, Your Honor, that the Commonwealth has given you everything you need throughout this trial to find Ms. McGee guilty of involuntary manslaughter under this theory. But I'd like to address the first element, that the defendant caused the death of Andrew Savitz. How do we know this? Well, you heard the opinion of Dr. Diedrich, a well-qualified medical examiner. She told you she had performed over 3,000 postmortem exams. She's board certified. She's been qualified numerous times as an expert in court. She told you that she used her own experience, her training, her observations, and information contained from medical records and 2 different police reports to reach her opinion. And I will remind you that Dr. Diedrich opined that the cause of death was cardiac dysrhythmia following an altercation in a person with hypertensive and atherosclerotic cardiovascular disease and diabetes mellitus. Dr. Diedrich also opined that the manner was homicide, a classification that was permitted by the name guidelines, and she told you that that was a medical definition, not a legal term. Again, Dr. Diedrich told you, but for this altercation with Penelope McGee, Andrew Savitz would not have died that night. Dr. Diedrich also told you that a significant factor in her opinion was the timing of the sequence of events. And I submit to you, Your Honor, that the timing of the sequence of events is also important in the legal causation of Mr. Savitz's death. I urge you to consider the timeline that you heard from when Zuzi Savitz called 911 and the testimony of the paramedic, Kevin Robichaud, and then the testimony of Dr. Olufadeji. Zuzi was on the phone when Mr. Savitz collapsed. She told you as she was calling 911, she could see her mother shoving her father in the chest multiple times and slapping him. And while that call was in progress, a 4-minute call, a little more than 4 minutes long, during that 4 minutes, she saw them arguing. She witnessed the shoving and the slap. Her father collapsed. And then you heard the paramedic tell you that they were dispatched at 11:08. They were at the scene at 11:09. They were at the patient at 11:10. They were at the hospital by 11:43, and then the time of death was called at 12:14. A very close in time, important sequence of events. Your Honor, Dr. Diedrich also told you about what ill health Mr. Savitz was in. She noticed a number of cardiovascular injuries, including a 90% stenosis of his carotid artery, diabetes, and other indications of severe cardiovascular disease. However, Dr. Diedrich did not classify this as a natural death. You heard evidence of Penelope McGee arguing with Mr. Savitz, yelling at him, acting frantic, angry, erratic, according to her daughter, eventually becoming so enraged that she pushes and shoves him multiple times and slaps him in the face. That escalating behavior, Your Honor, is what I submit to you Dr. Diedrich was referring to when she told you about the flood of hormones, the fight or flight response, the misfiring of his heart that she described. Penny McGee was right there when he collapsed. There was no break in that sequence of events. Andrew Savitz never recovered. Therefore, Your Honor, I submit to you that Penny Savitz was the cause of Andrew Savitz's death. Now I'll move on to the second element, which is that the defendant intended the conduct that caused the victim's death. Now, how do we know this, Your Honor? Nothing you have heard over the course of this trial, I would submit to you, suggested that any of Miss McGee's actions were an accident. Penny McGee intentionally went over to the house that night. She drove herself there. She was angry about the eviction process, and she was there to confront him. Recall the description of Miss McGee's behavior by her daughter Zuzi. She was frantic, erratic, angry. And when she saw them arguing, recall the description of what Zuzi said was happening. Penny was pushing back to him. She was shoving him. Penny was shoving his chest with her hands. Her hands touched his face. She slapped him once, and he had his hand up in kind of a defense. I ask you, Your Honor, do those sound like accidental touchings or unintentional touchings to you? I submit that they were the intentional actions of a furious woman who had had a little bit of wine earlier in the evening, who had already been evicted from one house, and who was being asked to leave another. Now, the third element. The defendant's conduct was wanton and reckless. Wanton and reckless conduct, Your Honor, is conduct that creates a high degree of likelihood that substantial harm will result to another. It is conduct involving a grave risk of harm to another person that a person undertakes with indifference or disregard of the consequences of such conduct. Think of the disregard Penelope McGee had for Andrew Savitz as she went to his house angry, confronting him with that email. Again, she was yelling, frantic, erratic. She had consumed alcohol. According to Zuzi, she was stumbling, she was slurring her words, and the argument became so heated, the discussion escalated into an argument, according to Penelope, that a large ceramic bowl broke in the kitchen. Despite that fact, Your Honor, despite the fact that Penelope knew that Andrew had a series of serious health conditions, she engaged in this erratic behavior. She argued with Andrew Savitz until she had him in the hallway and was physically attacking him. This is behavior that I would suggest to Your Honor is exactly the type of behavior that would pose a grave risk of harm to a person who was in the fragile state that Mr. Andrew Savitz was in. Your Honor, I suggest that a reasonable person would have known, and Penelope McGee should have known, that physically attacking a 66-year-old man that was experiencing cognitive issues, wore a glucose monitor for his diabetes, had suffered a stroke 6 months ago, had a 90% blockage in his carotid artery, had high blood pressure, depression, had been in a car accident just 6 days before, would have created a high likelihood that substantial harm would result to him. I submit to Your Honor that these actions were taken by Penelope McGee with an utter indifference to their consequences. Why should Ms. McGee have known that her actions would have caused a grave risk of harm to Mr. Savitz? She had plenty of knowledge of all of these conditions and the ill health that she was in. And the court has seen multiple items of evidence to suggest this fact. She was aware of the seriousness of his health conditions. She was his primary caretaker after the stroke. She helped him recover from his first car accident in August of 2019. She knew about the blockage in his carotid artery and the looming possibility of vascular surgery. She was the one that was updating his brothers about his status and what the doctors were saying. She took him to his doctor's appointments. She was his healthcare proxy. You have evidence before you that she was very active in his medical care and his planning. And I would draw your attention, Your Honor, to the medical records from the Newton Wellesley Hospital from August of 2019, specifically pages 148 through 178. In those pages, Your Honor, you will see that there are several notes to Ms. McGee being at his bedside, talking to the doctors. The nurse's notes indicate that ex-wife was, on page 171, ex-wife was updated. Ex-wife will assist with the discharge plan. Your Honor, contained within those medical records was the discussion of the stenosis in his carotid artery and the possibility of the vascular surgery. And in fact, both Mr. Savitz and Ms. McGee were updated that he was to do a follow-up in 4 to 6 weeks to consult with vascular surgery. There's also discussion in those pages, Your Honor, of the medications for diabetes and high blood pressure and depression. Your Honor, I would also draw your attention to exhibit number 10. Ms. Crawford, could we please see exhibit number 10? If you could please zoom on the yellow paragraph. Your Honor, I would draw your attention to this exhibit and specifically the text message from Penny Savitz from August 24th of 2019 after he had gotten out of the hospital, informing his brothers on the update of his health and the various conditions, including that he has a clogged left carotid artery, may require vascular surgery, but not urgent at this point. And I would again draw your attention to the medical records where it indicates to do a follow-up 4 to 6 weeks after that. Your Honor, this exhibit, this text message to John Savitz shows, Your Honor, that Ms. McGee was part of the medical care and planning. She was retaining that information. She had an understanding of his medical conditions, and she was reiterating it to his brother. And the defense has argued to you, Your Honor, that that was back in August. And how would Ms. McGee know that he was in such ill health moving ahead to January? I think he indicated that she had nursed him back to health by the time this incident happened. But I would suggest to Your Honor that the evidence is quite contrary. We could please see exhibit number 11, Ms. Crawford. Your Honor, in exhibit number 11, January 22nd, 2020, only 6 days before Mr. Savitz passes away, Mr. Savitz had had his second car accident, another serious one. And in this text message at 1:57 p.m., at the bottom of this paragraph, Ms. McGee indicates that she doesn't think Andy can live alone or take care of Harry. We need a better alternative. If Ms. McGee had thought that Mr. Savitz was nursed back to health by January of 2020, why would she be suggesting to her brothers that he could not live alone? She indicates further back in this paragraph that her son Noah calls her and asks her when his father's going to die. Your Honor, I would submit to you that this was not a person that had been nursed back to health, but was still suffering from many of these serious health issues that had been ongoing for several months that Ms. McGee was well aware of. Now, Your Honor, defense talks of the inconsistent statements of Zosie Savitz. I would submit to you, Your Honor, Zosie Savitz was very clear in all of her statements that there was some physical attack by her mother upon her father. She told you on the stand he was pushed and shoved multiple times and slapped once. Your Honor, the 911 call is very telling that Zosie Savitz just saw her mother do this to her father. It is true, you hear in the call, guys, stop, stop, dad, stop, stop, dad. But what you also hear, Your Honor, is just after Mr. Savitz collapses, Zosie utters to her mother, "Look what you've done." And I'd like to play that section for you, Your Honor, so that you can isolate it out so you can hear it. Ms. Crawford, could we please play clip number 1? You hear, Your Honor, the dispatcher ask if he's breathing. Zosie says he's breathing. The dispatcher says he's breathing, and right after that, Your Honor, Zosie says, "Look what you've done." Ms. Crawford, could we please play clip number 2? What you've done. Your Honor, I ask you to credit the statement of Zosie Savitz about what she had witnessed during that 911 call. Again, she told you she saw her mother shoving and slapping. And she looks at her mother and says, "Look what you've done." I would suggest to you, Your Honor, that that is an excited utterance made after an extremely exciting, terrifying event that should be credited. Now I'd like to turn to the 4th element, Your Honor, and that is that the defendant did not act in proper self-defense. The Commonwealth must prove that the defendant did not act in proper self-defense. And I submit to you, Your Honor, that the defendant did not use all reasonable means of escape to escape the physical combat. The law requires that a person must retreat unless it's not reasonably safe to do so. Your Honor, Penny McGee did not retreat, and the evidence that you have seen before you shows that she reasonably could have. Ms. McGee was not welcomed in the house of Mr. Savitz as that argument progressed. You heard from Zosie that her father was trying to get her mother to leave. You heard from Officer Yanez that even Ms. McGee said that Andrew Savitz was trying to get her to leave that house. There was nothing stopping Ms. McGee from leaving, Your Honor. There were two doors that were reasonably close to one another. Her car was parked outside. She was being asked numerous times to leave. Ms. McGee could have just left. She did not have to push him. She did not have to slap him. She did not retreat before using the physical combat that ultimately resulted in a flood of hormones that caused Mr. Savitz's collapse and his ultimate death. In conclusion, Your Honor, I would just remind the court, I know the court is extremely familiar with the standard of reasonable doubt, and that it is not proof beyond all possible doubt, because everything in our lives is subject to some possible doubt. But if you have in your mind an abiding conviction to a moral certainty that the charge is true, then this is the proof that you need. I submit to Your Honor that the Commonwealth throughout this trial has given you the proof that you need. The testimony of John Savitz, the testimony of Zuzi Savitz, the very qualified paramedic, the emergency room doctor, and Dr. Diedrich, the medical examiner. That, coupled with the medical records and the text messages and the emails, I am confident, Your Honor, that when you consider all of the evidence that was put before you, that you will find the defendant, Penelope McGee, guilty as charged. Thank you.
Thank you very much. So I don't need to recess to deliberate. I just want counsel to know, Ms. McGee to know, and the record to be clear that I have gone through all the exhibits. We were half days last week. Friday afternoon, I got to go through most of the exhibits. Mr. McDermott was kind enough to help me get together the medical records. I went through them this weekend, and we had last night and this morning to review everything that was admitted this week. So I've gone through everything. Ms. McGee, would you stand, please? On manslaughter regarding, on the theory of wanton or reckless conduct, I find you not guilty. And manslaughter caused by a battery, I find you not guilty. So.
Ms. McGee, your discharging was held in another process. There being no other process, you're hereby discharged. Thank you.
Thank you very much.
All right, please.
Appreciate you.
Congratulations.
Pleasure to meet you. Thank you very much. I appreciate it.
no problem.
Take care. It's a pleasure to
You
meet
too.
you. See you kindly.
Yes.
And I'm rooting for her. She deserves it.
Do you want to say anything on camera?
Pardon?
Do you want to say anything on camera? Or better?
I haven't had anything prepared.
That's fine.
Sorry.
Okay, no problem.
I don't know. Thank you. What? I know.
You deserve to be happy.
What time is Jennifer's interview?
At noon. So she's probably still